Hey guys, welcome back to the channel. This is the House of Law and I'm attorney Al Jumrani. So it's May 2, 2021. So that means yesterday was May 1, 2021. So belated happy Labor Day, everybody. If you still have a job, if you are still working, then be grateful, be thankful. It's been a very difficult year. It's been a very difficult life because of the COVID-19 pandemic. So your job is a blessing. Okay, so cherish it, fight for it, and protect it. Now, for those who have lost their jobs because of the pandemic, I'm sorry to hear that, and I'm praying that you will be able to bounce back and weather the storm, which is this pandemic. All right, now, speaking of May, we are now counting the days, weeks, and months before the November 2021 bar exams. I know there are bar viewees who have already enrolled in the formal bar review, so good luck to you all. You know what to do. Focus, focus, focus. Okay. Now, the number of students who will be, or the number of examinees who will be taking the bar exams will have to increase, no, because of the graduates this coming June or July. May mga graduate pa eh. So, medyo madadagdagan pa yan. We're expecting around 12,000 or more bar examinees. So, that will be a very daunting and difficult task for the bar exams committee at lalo na sa mga bar examiners. Kaya nga, parang, ginawa na nga tatlo ang examiner per subject. Now, whether this will be the easiest bar because it's computerized or the most difficult bar kasi sa sobrang dami gagawin nila, pahirapan nila para kukonti lang pumasa, do not entertain those thoughts, please. Yan. So instead, just focus, 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 no? Mas mabuti na isipin nyo na lang, okay, this is the most difficult bar, so I will give it my best and I will not leave any stone unturned. Okay? So, kapag meron kang binabasa, make sure you read and understand everything. Pag meron ka pang hindi nabasa, basahin mo na agad. Okay? Now, our job here, my job particularly, is to help you better understand the subjects, okay, the topics which I'm making a video on. And hopefully, by just listening or watching my videos, you will be able to recall the important concepts, mas familiar sa inyo. Tapos pati yung examples na binibigay ko, sana tumatak sa utak nyo, no? Now, if you know of people who would find these videos or my channel helpful, please share nyo na rin sa kanila para at least maraming pumasa. Now, hopefully, my aim is that pagdating ng bar, masyado nang madali sa inyo ang civil law na yung bang maiisip nyo, bakit may civil law exam pa? Napakadali lang yan. Bakit tinatanong pa? Ganyan. Ganyan dapat yung magiging yung preparation nyo for this subject. Para at least, di ba, pagka nag-bar na kayo or pag malapit na ang bar, mag-focus na lang kayo dun sa ibang mga subjects. I want this subject to be very easy for you para at least pampahila din ng grades nyo. Okay, so share this channel, share my videos para mas marami ang matulungan. Alright, so speaking of tulong, today's video is on guarantee and suretyship. Still part of civil law, particularly credit transactions. Ayan, so are you ready? Okay, so let's begin. Alright, so what will you learn from this lecture? Una, definitions and concepts. Hindi talaga mawawala yan. Pangalawa, differences between guarantee and suretyship. Pangatlo, benefit of excusation. Pang-apat, benefit of division. Next, benefit of contribution. And next, what obligations are covered by a contract of guarantee or suretyship. Now, as bonus, I will be discussing, although very briefly lang naman, some cases of the Supreme Court which I find important or relevant to this subject. All right? Okay, let's continue. Now, what is a guarantee? A guarantee is a contract where a person called the guarantor binds himself to another called the creditor to fulfill the obligation of the principal debtor in case the latter should fail to do so. So a guarantee is a contract, so all the elements of a contract should be present. Meaning, dapat may consent, may object, at may cause or consideration. So sino ba dapat ang magbibigay ng consent? Well, unang-una, guarantee is a three-way contract. Threesome. Okay. Yan, kung mahilig kayo mag-threesome. So it's a three-way contract because generally, a contract is a two-party contract. So you have the creditor and the debtor, or the obligor and the obligee. But here, you have another party, the third wheel. Yun yung guarantor. So sino ba dapat ang magbibigay ng consent to the contract? Well, the debtor must also give his consent to the guarantee. Also, the creditor must also give him his consent to the guarantee. Now, there are two relationships. No? Well, actually, three relationships na. The principal relationship between the creditor and the debtor, the relationship between the debtor and the guarantor, and the relationship between the guarantor and the creditor. Ayan. So, dapat may consent yan. Otherwise, there is no contract of guarantee. Okay. Pangalawa, there should be an object. And this object or subject matter is the principal obligation of the debtor. So kung wala yung principal obligation na yon, or kung bayad na, then the contract of guarantee does not exist. And lastly, there should be a cause or consideration. Well, all contracts are presumed to have a considerable or a valid consideration. No? So kaya presumed naman yun. Now, it could be onerous, it could also be gratuitous, but there is always a presumed consideration or cost in a contract. Ayun. So, okay. So, yun. Tatandaan nyo yun. Alright. Now, what are the characteristics of a guarantee? So, una-una, it is a consensual contract. Ibig sabihin, it can be perfected by mere consent. For after all, a guarantee is a contract that involves an obligation to do something, okay? Not to give something. Yung mga obligations to do something usually require only consent or meeting of the minds. Pero kung yung mga obligations to give something, tulad ng loans, deposits, ganyan, dapat merong delivery of the thing for the contract to be perfected. So in this case, a guarantee does not involve the delivery of a thing. It only involves the commitment or the undertaking to answer, o diba? Obligation to do. What is that to do? It is to answer for the obligation of another. So kaya consent is enough, okay, for the perfection of the contract. Now, the other characteristic is that a contract of guarantee is an accessory contract because it is dependent for its existence upon the valid principal obligation guaranteed by it. So if there is no principal obligation, then the accessory contract of guarantee does not exist. Now, the third characteristic is that it is subsidiary and conditional. Subsidiary because a contract of guarantee is secondary to the principal obligation. And the creditor has the right to run after the guarantor only if the debtor fails to pay. So in other words, there is a condition that must be met. So it's a suspensive condition, the happening of which gives rise to the obligation of the guarantor to answer for the obligation of the debtor. All right. Now, lastly, it is a unilateral contract. Pero, tatandaan, this only applies with respect to the relationship between the guarantor and the creditor. Between the guarantor and the creditor, it is only the guarantor who has an obligation to perform. Okay, so pag hindi nagbayad si debtor, yun lang yung time na magbabayad si guarantor dun sa creditor. Si creditor naman, wala naman siyang obligation kay guarantor, di ba? Kaya one-way street lang. Pero with respect to the guarantor and the principal debtor, bilateral na ang contract doon. Bakit? Kasi may obligation si guarantor to pay for the obligation of the debtor. Si debtor naman, meron din siyang obligation to the guarantor to reimburse or indemnify the guarantor what he has paid to the creditor for the benefit of the said debtor. All right. Now, suretyship is a species of guarantee. It is an agreement where a party called the surety guarantees the performance by another party called the principal debtor or obligor of an obligation or undertaking in favor of a third person called the obligee. Okay. Now, a surety's liability is joint and several. Ibig sabihin, solidary. Okay? limited to the amount of the bond, and determined strictly by the terms of contract of suretyship in relation to the principal contract between the obligor and the obligee, or the debtor and the creditor. Now, tandaan niyo yung lessons natin on obligation and contracts, particularly on joint and solidary obligations. Solidary obligations are those obligations where the debt is due and demandable regardless of how many debtors there are. No? So, each debtor shall be liable for the entire obligation. So, ganun sa suretyship. The surety is liable primarily and immediately, okay, for the debt. And same with the debtor. Pero sabay sila, para silang principal debtors din. In the case of a guarantee, the guarantor is only subsidiarily liable, not primarily liable. Okay, now, because of the solidary nature of the obligation, the surety is not an indispensable party in a suit against the principal. Neither is the principal an indispensable party in an action to claim indemnity from the surety. Right? So, pwedeng i-demanda na agad si surety kahit hindi kasama sa asunto si principal debtor. Ganun din, no? Pag dinemanda naman si principal debtor, hindi kailangan isama si surety dun sa kaso. Alright. Now, what's the difference between guarantee and surety? Well, una-una, they are similar because both promise or undertake to answer for the death, default, or miscarriage of another. But they are different in the following ways. So first, the liability of a guarantor depends upon an independent agreement to pay the obligation of the principal if he fails to do so. The surety assumes liability as a regular party to the contract. Ayan yung sasabi natin, as a solidary debtor, he is a party to the contract. Now, a guarantor's obligation is secondary, a surety's obligation is primary. A guarantor's undertaking is to pay if the principal debtor cannot pay. A surety's undertaking is to pay if the principal debtor does not pay. Now, is there a difference? Of course, there is a difference. Pag sinabi mong cannot pay, hindi na niya kaya. Like, I cannot. Ayan, ganyan. I cannot. K-E-N-N-A-T. Huwag niyong gagamitin yan sa bar ha. Baka yan ang maging spelling ng cannot niyo ha. So, I cannot is C-A-N-N-O-T. Okay. So, the debtor can no longer pay or cannot pay because he has no money, he has no assets, whatever. So, that's the time that the guarantor is held liable. Pero in the case of a surety, all it takes is for the debtor to refuse to pay. Ayaw niyang bayaran. Hindi ibig sabihin hindi niya kayang bayaran. Hindi lang niya binayaran. Ayaw lang niyang bayaran. So in that case, the surety is already liable. Okay? Now, a guarantor is an insurer of the solvency of the debtor. A surety, on the other hand, is an insurer of the debt. Now, meron bang difference doon? Yes, meron din. So, the guarantor assures the creditor that this debtor has sufficient assets or properties, okay, to pay you. Pag naubusan siya ng assets or wala na siya assets na pambayad sa iyo, then that's the time I will pay you. Okay? Ganun ang sasabihin. Ganun ang linya ni guarantor. Pero si surety naman, dahil insurer siya ng utang. So, ang linya niya is that babayaran kita pag hindi nagbayad si debtor. So, hindi niya kailangang hintayin na maubusan ng property si debtor or na mag-file muna ng kaso si creditor against kay debtor to proceed against the properties of the debtor. Pag hindi nagbayad si debtor, then ang linya ni surety is that babayaran kita pag hindi nabayaran yung utang. Yan. Now, last difference is that a guarantor is entitled to the benefit of excussion, but a surety is not entitled to such benefit. Okay. More on the benefit of excussion in a while. All right. Now, guarantee and surety are contracts of personal security. What are these contracts of personal security and how are they different from contracts of real security? Well, in the case of Acme Shoe versus Court of Appeals, GR number 103576, the Supreme Court explained the difference. So, contracts of security are either personal or real. In contracts of personal security, such as guarantee or a suretyship, the faithful performance of the obligation by the principal debtor is secured by the personal commitment of another, meaning the guarantor or surety. In contracts of real security, such as a pledge, a mortgage, or an anticrisis, that fulfillment is secured by an encumbrance of property. Okay, so paano ba mas madaling tandaan to? Pag sinabi mong personal security, may taong involved. Okay? Pag sinabi mo namang real security, may property involved. Of course, syempre, meron ding person involved doon, yung principal debtor or yung accommodating party na may-ari ng property. But in a personal security, the collateral or the security there is the promise or commitment of another person na babayaran niya yung utang pag hindi nakabayad yung principal debtor. Pero sa real security naman, the promise there is for the property to be used. Okay? And its proceeds will be applied to the payment of the debt. Kaya nga may tatawag tayong foreclosure. Yan. So that's the difference. All right, now let's look at the kinds of guarantee. So as discussed, we have personal guarantee if it refers to the promise of another person. Real guarantee if what is given as security or assurance for the payment of the obligation of the principal debtor is property or some kind of property or real rights. Yeah, that's real guarantee. Now, a guarantee can also be conventional, legal, or judicial. Conventional guarantee means that it is voluntarily agreed upon by the parties. A legal guarantee, on the other hand, is a guarantee that is required by law. Judicial guarantee, on the other hand, is a guarantee that is required by the courts. For example, a supersedeas bond, okay, or a bond in order to have an extrajudicial settlement registered, mga ganyan. So those are judicial. Sorry, hindi pala judicial bond, yung legal bond yun, yung sa extrajudicial settlement. Pero ang supersedeas bond, yan yung judicial bond or judicial guarantee. O, diba? So alam nyo na. Okay, next. A guarantee can also be gratuitous or onerous. It's gratuitous when the guarantor does not receive compensation for his undertaking. It is onerous if the debtor pays the guarantor for his pays compensation to the guarantor for his undertaking to answer for the debt or obligation of the principal debtor. Now, an obligation can also be definite or indefinite. A guarantee is definite if it is limited to the principal obligation, nothing more, nothing less. But it's an indefinite guarantee if it comprises not only the principal but also its accessories and costs, yung mga additional charges and all that. Now, this is very similar or very related to what we call a continuing guarantee. So, ano ba yung continuing guarantee? A continuing guarantee covers all transactions, including those arising in the future. In other words, future debts. Okay, so future debts may be secured by a guarantee, even if the exact amount is not yet known. However, the guarantor cannot be sued until the debt is liquidated, which means that the amount of the debt is already determined or fixed. All right, so that's a continuing guarantee, although it doesn't mean that there is no valid obligation there. There is still a valid obligation, and although it is yet to be entered into or yet to be born. Okay, more on continuing guarantee in one of the cases later. So just watch out for that. Now, assuming a guarantee exists, what are the effects of payment by the guarantor? So first, effects of guarantee without notifying the debtor. So the guarantor may recover from the debtor what he paid to the creditor, but only to the extent of the benefit enjoyed by the debtor. This is similar to Article 1236 of the Civil Code on a situation where a third person pays the obligation of another, in which case the latter has to indemnify or reimburse the other person who paid for the obligation insofar as he was benefited by such payment. Now, the reason for this rule is to prevent unjust enrichment. Diba? Unjust enrichment goes against the grain of law and equity. So that's why he who has been benefited by the payment of another should reimburse or indemnify the other, at least to the extent that he was benefited. But note the following. First, if the guarantor should pay without notifying the debtor, the latter, meaning to say the debtor, may set up or enforce against the guarantor all the defenses available against the creditor. So, for example, if the obligation is already prescribed or the obligation has already been extinguished, then the debtor can raise that against the guarantor to prevent recovery. Now, you may wonder, paano yun pagka hindi na mabawi o hindi na masingil ni guarantor sa debtor yung binayad niya kay creditor, so ano mangyayari? Well, in that case, the guarantor can also raise the same defenses which were raised against him. For after all, these defenses go into the debt, not only into the person of the debtor. So, the principle of solution indemnity can apply. The guarantor can recover what he has paid by mistake or what he has paid to the creditor when the creditor has no right to receive or to demand it. All right. Now, the next thing to remember is that if the debt was for a period and the guarantor paid it before it became due, then the guarantor cannot demand reimbursement until the expiration of the period. Remember that in obligations with a period, the period is for the benefit of the debtor. So the debtor cannot be compelled to pay the obligation prior to the arrival of the period. Okay, so in that case, the guarantor has to respect the period and will only be paid upon the arrival of the period stipulated. Now, lastly, if the guarantor paid without notifying the debtor and the debtor repeats or duplicates the payment, the guarantor can only collect from the creditor. Okay, the priority is still the payment of the principal debtor. All right. Now, effects of guarantee naman with the consent of the debtor, which is the ideal situation. Okay. So first, the guarantor is subrogated to all the rights which the creditor may have against the debtor. So it could be a right to recover payment or the principal obligation, interest, or even damages. All right. Now, this results by operation of law from the act of payment, and there is no necessity for the guarantor to ask the creditor to expressly assign his rights of action. Automatic yung subrogation na yan. Now, the obligation of the debtor subsists. There is just a change in the person of the creditor of the principal debtor. So, novation lang siya, no? But well, actually, it's not really a novation. It's just a change in parties, but the obligation remains. Yeah, so that's guarantee. Okay, now what can be the subject of guarantee? So, any valid obligation in a sum of money can be the subject of guarantee. So, it could be a valid existing obligation. It could also be a voidable obligation, an unenforceable obligation, or a conditional obligation. So, bakit kasama ang voidable? Hindi ba valid ang, di ba invalid ang voidable obligation? No, a voidable obligation is a valid obligation until it is annulled or set aside. So, since it is a valid obligation, then it can be the subject of a contract of guarantee. Now, how about an unenforceable obligation? Hindi ba invalid yun kasi nga unenforceable? Ano ba? Enforceability is different from validity. Enforceability means that it cannot be proved. Okay, but it is valid between the parties, no? They have validly entered into, pero hindi nga lang siya ma-prove. So, pag dininay ng isa, hindi talaga siya ma-prove. But it can be ratified. So, once it is ratified, then it now becomes enforceable. So, as far as the validity is concerned, the contract is valid. Meron lang problema sa enforceability. So, that too can be the subject of a contract of guarantee. Now, conditional obligations are valid obligations that are subject to a condition, whether resolutory or suspensive. So, because it's a valid obligation, then it can also be the subject of a contract of guarantee. All right. Now, what are the limits of guarantor's liability? So, number one, it cannot go beyond the obligation of the principal debtor because the contract of guarantee is merely accessory. So, ibig sabihin, if the principal obligation is for a principal loan, for a loan of money, but without stipulation as to interest, then the guarantor cannot be held liable to pay interests. His liability is only the liability of the principal obligation. Yeah. So the spring cannot rise above its source, so to speak. No? So the guarantee finds its existence or its validity from the principal obligation, so it cannot go beyond it. All right, next, the limitation on the liability of the guarantor applies both to the amount as well as to the onerous contract of the obligation. Okay, so ibig sabihin, yung principal obligation at saka kung may interest, then including the interest. Okay, question. What is the legality of a guarantee which exceeds the principal obligation? The guarantee is not rendered void. However, the same shall be reduced to the extent of limit of the debtor's obligation. So what has been paid by mistake or what has been paid without right to receive or to demand it shall be returned, again following the principle of solutio in debiti. Right. Now, is there a required form of the contract of guarantee? The answer is no. There is no required form for validity, but there is a required form for enforceability. Now, there is a required form for enforceability because that is the proof of the contract. Okay? Because a contract of guarantee, according to Article 2055, cannot be presumed. Okay? So the declarations of one, verbal declarations of one, cannot be accepted. Okay? Because the law, particularly Article 1403, paragraph 2b, requires that a written evidence of the contract should be made because this is a special promise to answer the debt default or miscarriage of another. Okay, so remember that the parties can enter into it. Okay, they can give their consent. They can have a meeting of the minds, as we have said earlier. The contract of guarantee is perfected by mere meeting of the minds, but for its enforceability, and for it to be enforceable, it should be in writing. Again, following Article 1403, paragraph 2b of the Civil Code. However, the contract of guarantee need not be in a public instrument. Hindi po siya kasama doon sa mga contracts na kailangan ay nasa public instrument, which you can find under Article 1358 of the Civil Code. All right. Now, what are the qualifications of a guarantor? So, kailangan ba talaga may qualifications? Di ba pera lang ang habol? Hindi it's not all about the money. Okay. So, kung magjojowa ka, wag lang pera ang habulin mo, no? Ang hanapin mo. Kundi pati yung personality. Particularly, the following characteristics or qualifications must be present in the guarantor. Una, he must be a person of integrity. Ibig sabihin, meron ba siyang word of honor? Is he someone you can trust? Does he have a good reputation for complying with his obligations and making good his promises? Ayan. Kasi kung hindi mo siya mapagkakatiwalaan at wala siyang salita, ayan, di wag siya. Okay. So that's why he must be a person of integrity. Pangalawa, he has full legal capacity. And by legal capacity, it is not limited to just entering into contracts. Ibig sabihin, hindi enough na he is of majority age, no? He must also have legal capacity to manage and dispose his property, especially because the next characteristic requires that he has sufficient property to answer for the obligation of the debtor. And he has sufficient property which he can freely dispose. So, kailangan yung full legal capacity. Now, in the following cases, a creditor may demand a substitute guarantor. Okay? So, first, pagtsaka ang guarantor. Hindi, wala naman sa mukha yan. Nasa personality yan. Okay. It's the inner beauty, not the outer beauty. Pero for purposes of guarantor, walang pakiambata sa itsura. Dapat dun tayo sa capability to answer for the obligations of the debtor. So, number one, if the original guarantor is convicted of a crime involving dishonesty like estafa and misappropriation because it goes into the integrity of the person. So, kaya, tsugi, palitan na agad yan. Okay, next, in a situation where the original guarantor becomes insolvent. Okay, now, you might ask, ba't ganun, di ba dapat ang debtor lang ang solvent? Bakit pati ang guarantor solvent? You know, in a contract of guarantee or in a contract of loan where there is a guarantee, mas importante na solvent ang guarantor. Ibig sabihin may enough properties ang guarantor. Okay, never mind that this debtor may turn up to be insolvent later. Basta importante yung guarantor na nangakong magbabayad pag hindi kayang magbayad ng debtor is solvent kasi siya ang hahabulin. Okay, now, so if he becomes insolvent, then the creditor can demand that the debtor give a substitute guarantor. Now, ang tanong ngayon, paano kung hindi makapagbigay ng substitute guarantor si debtor? Wala na siyang mahanap, wala nang willing, 'di ba? Dumating na ba sa point niya na gusto niyong mangutang tapos sabi ng bangko sa inyo, oh, kailangan mo maghanap ng co-maker tapos wala kang mahanap na co-maker. Kasi nga 'di ba, ang hirap maging co-maker as you will know, no? In this case, no. Although pag sabi mo co-maker, that's a very general sense. No? Pwede kasing co-maker, ibig sabihin signatory ka doon sa utang, or co-maker, you will issue checks, no, for use by your friend or by the principal debtor or co-maker in the case of a contract of guarantee. So yun. But the responsibilities, no, are too difficult to bear. So that's why it's very difficult to find a co-maker. So ano mangyayari pag if the debtor is not able to provide a substitute ano daw? Substitute guarantor. So the obligation becomes due and demandable, and the creditor can demand the payment of the unpaid obligation. Hala, bakit ganun? What if this debtor has been granted a period and yun, hindi siya nakahanap ng guarantor, substitute guarantor, due and demandable na agad? Yes. Because the reason why a debtor has been given a period, meaning to say a credit, is because of the trust that this debtor will be able to pay or someone has promised to pay the debt in case this debtor will not pay. So, binigyan siya ng period kasi nga merong nangako na sige pag hindi nagbayad yung principal debtor ako magbabayad. Ngayon biglang nawala yung nangakong magbabayad. So definitely the obligation now becomes due and demandable. It can be collected immediately by the creditor. Ayan. So yan po ang effect. Now let's talk about the benefit of excussion. So what is this benefit of excussion? Under the benefit of excussion, the creditor has to resort to the properties first of the debtor. The guarantor cannot be compelled to pay the creditor unless the latter has exhausted all the properties of the debtor and he has resorted to all the legal remedies against the debtor. In a contract of guarantee, always remember that the guarantor's liability is subsidiary and secondary. Dapat unahin munang habulin si debtor. So what are the requisites for the benefit of excussion to prosper? So first, the guarantor must set up the right against the creditor upon the latter's demand of payment upon him. So this means that a final judgment must have been rendered previously against the debtor and it was not satisfied. So if the guarantor raises that, then the creditor must first proceed against the debtor, and only after a final judgment has been issued and the debtor did not satisfy that final judgment, will that creditor now go after the guarantor. Now, the second requisite is that the guarantor must be able to point to the creditor the available properties of the debtor. So if there are no more properties of the debtor, then the benefit of excussion is no longer available. Okay? Or even if there are properties that were pointed to by the guarantor, but these properties were already attached or were already used up, then again, the benefit of excussion will not be available. But in the following situations, the benefit of excussion is not available. So first, if the guarantor has expressly renounced or waived the right of excussion in the contract of guarantee. Second, if he has bound himself solidarily with the debtor, because in this case, he becomes a surety of the debtor, and his liability is primary and immediate. All right. Now, also in case of insolvency of the debtor, this means that the debtor has no more properties to answer, not just for this particular obligation, but for all his obligations. Okay. Next is when the debtor has absconded or cannot be sued within the Philippines unless he has left a manager or representative. Because there's no more debtor to be sued by the creditor. Kaya pwede nang habulin ni creditor si guarantor. And lastly, if it may be presumed that an execution on the property of the principal debtor would not result in the satisfaction of the obligation. So parang katulad lang din doon sa insolvency of the debtor. So filing a case against the debtor would be useless. Thus, the creditor is now entitled to go after the guarantor. All right. Now, the other thing to remember is the benefit of division. So, what is this and when does this apply? So, the benefit of division applies when there will be several guarantors of only one debtor and for the same debt. So, the obligation to answer for the same is divided among all. So, it's a joint obligation among and between the joint guarantors. Now, the liability of the guarantors is joint and proportional. So, in case the obligation is 100,000 and they agreed, and they are five, for example, and they agreed to share equally, so that's 20,000 pesos each. So, there is a division. So, each one of them will be liable only to their proportional share in the obligation. Now, the creditor can claim from the guarantors only the shares they are respectively bound to pay unless solidarity was stipulated. Okay, so kung solidarity was stipulated, then each one of them becomes a surety of uh, the debtor. Ayan. But of course, they are also entitled to reimbursement, and that is what is covered by the next benefit. And this is the benefit of contribution. So ano ba tong benefit of contribution? Well, under the benefit of contribution, a co-guarantor or a co-surety being joint debtors need not pay the entire obligation. But when one guarantor has paid the obligation of the principal debtor, he is entitled to the contribution from his co-guarantors. If any of the guarantors should be insolvent, then his share shall be borne by the other co-guarantors, including the payer, okay, in the same proportion. All right. So the benefit of contribution complements the benefit of division. Now let's talk about the guarantor's rights against the debtor. So the first is the right to indemnity, and this presupposes that the guarantors already paid the principal obligation to the creditor. So the indemnity here includes the total amount of the debt, legal interests, expenses, and damages, if any. Now, generally, after the payment of the principal obligation, the guarantor is already released and the guarantee is extinguished. I say generally because in some instances, the guarantee is a continuing guarantee. Kaya kahit na nabayaran na yung isang obligation ni debtor, tuloy pa rin yung guarantee because meron pa siyang, yung debtor may ibang utang pa na kailangang sagutin din ni guarantor. But let's say, okay, the obligation has already been extinguished, then the guarantor is released. Okay, but in these instances, in the following instances, even before the guarantor has been held liable under the guarantee, meaning to say, even before the debtor's principal obligation has become due and the guarantor has been asked or demanded to pay the obligation, the guarantor can ask to be released, or if not, can demand from the debtor some security to protect his interest as a guarantor. So what are these situations? Una, when the guarantor is sued for payment. Now, hindi ibig sabihin pagka dinimanda na siya for payment, he will ask to be released. Of course not, because that is precisely why he is a guarantor, to answer for the obligation of the obligation of the principal debtor. So what he can do is to ask from the principal debtor some security so that the guarantor will have some recourse, okay, to the debtor in case the guarantor pays the creditor. Now, the second situation is in case of insolvency of the principal debtor. Here, the guarantor can do two things. So first is he can ask for additional security or some security so that the guarantor can have a recourse to the debtor in case the guarantor will pay the creditor when the obligation becomes due. Or he can ask to be released because the reason is obvious that with the insolvency of the debtor, the guarantor will have no recourse, okay, to the debtor. Okay? Hindi siya mababayaran. Okay, now the third situation is when the debtor has bound himself to relieve the guarantor from the guarantee within a specified period and this period has expired. So if the guarantee has a specific period and the obligation has not yet become due, or no demand has not yet been paid, or sorry, no demand has been made yet, okay, on the guarantor and the guarantee contract has already expired, then the guarantor can be released from his obligation as a guarantor. Okay, now next, when the debt has become demandable by reason of the expiration of the period of payment. So same din, no? Pagka nagkaroon na ng obligation to pay, the guarantor can demand security from the debtor so that the guarantor can have a recourse to the debtor in case bayaran na niya si creditor. Okay? Pero hindi siya pwedeng ma-release, no, from that obligation because that is precisely why he is a guarantor. Okay, next. After the lapse of 10 years, okay, when the principal obligation is no fixed for its maturity unless it be such nature that it cannot be extinguished except with a period longer than 10 years. Well, this presupposes that a guarantor cannot be held liable for an indefinite period. Okay, so for a contract or a debt obligation which has no period, a guarantor will be liable only for up to 10 years. Okay? All right. So after the 10th year period, then he can be released. Now, next is if the debtor intends to abscond. So if the guarantor has a well-founded belief that this debtor is trying to flee the country or trying to make himself unreachable, okay, then the guarantor can ask to be released. Release na agad, hindi na yung hingi lang siya ng security. Because ibig sabihin nun, the debtor does not wish to provide the guarantor some recourse. All right. Lastly, if it is imminent that the debtor will become insolvent. Ayan. So dito naman pwedeng additional security. You know, if the debtor can provide some security to the guarantor, then the guarantor can proceed. But if not, then the guarantor can ask to be released because, again, he would not have any recourse to the debtor if indeed the debtor becomes insolvent. Now, let's talk about extinguishment of guarantee. So, what are the modes of extinguishment of guarantee? So the same grounds for extinguishment of obligations under Article 1231 of the Civil Code also apply to extinguishment of guarantees. Okay, so first, payment or performance. This means payment or performance of the principal debtor to the principal creditor. So if there is no more principal obligation, then clearly there is no more need for the guarantee is extinguished. Next, condonation or remission of the debt. In case the creditor condones or remits the debt, so quits na, wala nang utang, so clearly there is no more need for the guarantee will also be extinguished. Now also confusion or merger of the rights of the creditor and debtor. Now if you remember my lecture on obligations and contracts, I explained this situation in this wise. Let's say the creditor is company A, the debtor is company B, and in due time, company B, through a series of transactions, acquired, okay, the company of the creditor. So company B is now the owner of company A. So clearly there is only one entity, and that is company B. So he is the creditor of himself or itself. So that's why the obligation will also be extinguished. And since there is no more obligation, there is no more need for the guarantee will also be extinguished. Next would be compensation or set off. So if the creditor and debtor are creditors and debtors of each other, so they can cancel out their obligations. If one of those obligations that was canceled out was secured by this guarantee, then if that obligation is extinguished, then the guarantee would also lose its reason. Wala nang need for the guarantee, then the guarantee will also be extinguished. Now, next is novation. With a novation, the old obligation is extinguished and a new one is created. So let's suppose the obligation that was secured by a guarantee was novated and a new obligation was created between the principal debtor and the creditor. The guarantee is extinguished. Why? Because that guarantee relates only to the original obligation. At ano sabi natin kanina? The guarantee cannot extend beyond what was contemplated in the contract of guarantee. So, unless, of course, the exception is that if it is a continuing guarantee. But if it is not a continuing guarantee and it is only for that specific obligation, then the extinguishment of that specific obligation also results in the extinguishment of the guarantee. All right. Now, additional grounds are annulment, rescission, fulfillment of resolutory condition, and prescription. And all these relate to the contract of guarantee, not the original guarantee. I mean, not the original contract, but this contract of guarantee. So, for example, if the guarantor files an action for annulment of contract and the contract of guarantee is annulled, then of course the contract of guarantee is also extinguished. Same with rescission, same with the fulfillment of a resolutory condition, such as when the guarantee is subject to an expiry date or an expiration date. Okay, and also prescription. So let's say the guarantee was a written contract, and according to the law on prescription, actions based on a written contract will prescribe in 10 years. So if, let's say, the guarantor fails to pay the obligation and the creditor fails to enforce that contract of guarantee within 10 years, then of course the guarantee is extinguished. All right. Now, other grounds, release by acceptance of property by the creditor. So it's like a dation in pago. So it's the same as extinguishment of the obligation. It's just another mode of extinguishment of obligation. Also, release by the creditor in favor of the guarantors. So this may be with or without payment. Okay, so in that case, the guarantors are already released because after all, the obligation of the guarantor is to pay to the creditor. So parang si creditor, sabi niya, oh, sige, hindi ko na kaya habulin ha. Okay na kayo, uwi na kayo. Okay, something like that. Now also extension of term granted by the creditor to the debtor without the consent of the guarantor. Because again, sabi natin, the guarantee cannot extend beyond what was stipulated in the contract of guarantee. The obligation must be specified, and the guarantee cannot go beyond the original obligation. The exception is that when the guarantee is a continuing one. So, ibig sabihin, kahit na additional obligations pa yan or kahit na extended original obligation yan, the guarantor would still be liable. So, hindi to applicable itong third ground na to a continuing guarantee. And lastly, okay, when the guarantor, through some act of the creditor, cannot be subrogated, okay, to the rights, mortgages, and preferences of the latter. So, ibig sabihin, if the creditor has released the debtor or kung merong mga defenses si debtor against the creditor, which results in preventing the guarantor from stepping into the shoes of the guarantor, okay, to collect what it has paid to the guarantor, then that would also allow the guarantor to be released from its liability, okay, under the guarantee contract. So those are the modes of extinguishment of guarantee. So are we done yet? No, we're not done yet because let's discuss some cases of the Supreme Court on the topic of guarantee and surety. So, what are these cases? Gaano ba kadami to? Tingnan nyo na lang yung remaining time. So, di naman siya ganun kadami. Alright. So, the first case is Traders Insurance versus D. Ngyok, L-9073, decided November 17, 1958. Bagong-bago. No, just because it's all, it doesn't mean it's useless. Because here the Supreme Court ruled that a contract of guarantee or suretyship has prospective application and it cannot secure past obligations. Also, between an unsecured and a secured obligation, the secured obligation is the more onerous obligation for purposes of application of payment. All right. So, what are the facts? Eng Gyok was a sales agent of Destillera Lim Tauco and Company Incorporated. Now, Eng Gyok had unpaid obligations to Destillera from 1948 to August 1951 in the amount of 12,898.61. On August 4, 1951, Eng Gyok executed a surety agreement with Traders Insurance to secure Eng Gyok's obligations to Destillera from August 1951 to August 1952. So, 1 year ang effectivity or validity ng guarantee or suretyship agreement. All right. Now, in the same surety agreement, Eng Gyok had two counter guarantors or co-guarantors to indemnify traders insurance for whatever traders insurance may be bound to pay Destillera. Now, within that period, Eng Gyok made remittances or payments to Destillera in the amount of 41,864.49 for sales made during the same period, meaning August 1951 to August 1952. Okay. Now, Destillera, however, applied the payments to the past unpaid obligations, yung prior to August 1951, and demanded additional payment for the sales made from 1951 to 1952. Okay? Because nagkulang na. Kasi nga yung mga payments na dapat sana for 1951 to 1952, in-apply naman dun sa previous na utang. So, kulang na ngayon. Meron na namang utang si Eng Gyok. Okay. Now, Traders Insurance was forced to pay Destillera, and as a result, it demanded reimbursement from Eng Gyok and his counter guarantors or co-makers. Now, when they did not pay, Traders Insurance sued them in court. The trial court denied the complaint and absolved the co-guarantors, ruling that the suretyship was only for the obligations accruing within the period of 1951 to 1954 and not prior. Okay. However, the trial court ruled that Traders Insurance can recover from Eng Gyok what it has paid to Destillera. All right. So, question or issues: whether Traders Insurance and the counter guarantors are liable under the surety agreement. And second, whether Destillera was correct in applying the remittances of Eng Gyok to the past unpaid obligations of Eng Gyok. All right. So, what was the ruling of the Supreme Court? So, regarding the first issue, a guarantee or suretyship operates prospectively and not retroactively. That is to say, it secures only the debts contracted after the guarantee takes effect. Neither Traders Insurance nor the counter guarantors are liable to pay the past outstanding obligations of Eng Gyok. Okay, so mali talaga na binayaran ni Traders Insurance yung sinisingil ni Destillera, because Destillera was also wrong to apply the payments made by Eng Gyok to the past obligations. Now, regarding the second issue, the remittances made by D. Eng Gyok should be applied to the obligations contracted by him during the period covered by the suretyship agreement. In the absence of express application by the debtor or of any receipt issued by the creditor specifying a particular imputation of the payment, any partial payments made by him should be imputed or applied to the debts that were guaranteed, since they are regarded as more onerous debts from the standpoint of the debtor. Okay? So, sinasabi ng Supreme Court, dapat ang ginawa ni Destillera is to apply those payments dun lang sa period na covered by the surety agreement, which is 1952 to August 1951 to August 1952. But then, bakit? Okay? Yung isa, yung unsecured obligation which accrued prior to August 1951, hindi naman unsecured yun. Ibig sabihin ba, hindi ba mas onerous yun kasi wala kang security? Well, here the Supreme Court said that the debts covered by a guarantee are deemed more onerous to the debtor than the simple obligations, because in their case, The debtor may be subjected to action not only by the creditor but also by the guarantor, and this even before the guaranteed debt is paid by the guarantor. O di ba? Nabanggit natin kayo na yung mga rights of the guarantor against the debtor. So clearly, the debtor will answer to both the principal creditor as well as the guarantor. Kaya more onerous ang mga obligations that are secured. So in this case of Engyok's payment, those payments should have been made to those obligations that were secured by a suretyship agreement, meaning those obligations that accrued between August 1951 to August 1952. All right, now postscript PS. Although not discussed by the Supreme Court upheld the ruling of the trial court that Engyok is liable to reimburse traders' insurance for paying Engyok's past unpaid obligations to Distillera. Why? Well, the situation is a case of a third person who pays the debt of another. Under Article 1236 of the Civil Code, whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. All right. Yun. Okay, now the next case is Aglibot versus Santia. GR number 185945, December 5, 2012. Here, the Supreme Court ruled that a guarantee contract must be in writing to be enforceable. A guarantee is not presumed but must be expressed and cannot extend to more than what is stipulated therein. If the guarantee is not proved, the person promising to answer for a debt is deemed a solidary debtor. So, hindi siya subsidiary, hindi rin siya secondary, kundi primary and solidary debtor. Bakit? Ano kaya yung situation? Bakit ganun ang ruling? Let's see. So, facts. Santia loaned the amount of 2.5 million to Pacific Lending and Capital Corporation, or PLCC for short, through its manager Aglibot. Okay? So, nagpautang si Santia kay PLCC through Aglibot. Okay? Now, Aglibot executed a promissory note and issued 11 post-dated checks drawn from her personal account. When Santia presented the checks for payment, they were dishonored by the bank for having been drawn against insufficient funds. Santia filed a complaint for violation of BP 22, but it was dismissed. The Court of Appeals, however, held that Aglibot is civilly liable to pay the loan. Aglibot, however, claimed that she was merely a guarantor of PLCC and that Santia failed to exhaust the properties or assets of PLCC. So, Aglibot is demanding the right or the benefit of exclusion. Ayan, kaya dapat daw siningil muna ni Santia si PLCC. So, issues. Whether Aglibot was merely a guarantor of the loan of 2.5 million pesos and whether Aglibot is principally or solidarily liable to pay the loan. So, the ruling of the Supreme Court. As to the first issue, the Supreme Court rejected Aglibot's claim as a mere guarantor of the indebtedness of PLCC to Santia because there was no proof of that guarantee. In view of Article 14032 of the Civil Code embodying the Statute of Frauds, under the above provision concerning a guarantee agreement, which is a promise to answer for the debt or default or miscarriage of another, the law clearly requires that it or some note or memorandum thereof be in writing. Otherwise, it would be unenforceable unless ratified. When sasabi natin, a contract of guarantee should be in writing to be enforceable. Furthermore, Article 2055 of the Civil Code also provides that a guarantee is not presumed but must be expressed. Aglibot has not shown any proof such as a contract, a secretary certificate, or a board resolution, nor even a note or memorandum thereof, whereby it was agreed that she would issue her personal checks in behalf of the company to guarantee the payment of its debt to Santia. Okay? Now, by issuing her personal checks to pay PLCC's indebtedness to Santia, Aglibot bound herself as an accommodation party. Okay? Now, negotiable instruments to ha. Okay. The relation between an accommodation party and the party accommodated is in effect one of principal and surety, the accommodation party being the surety. Okay. It is a settled rule that a surety is bound equally and absolutely with the principal and is deemed an original promisor and debtor from the beginning. The mere fact then that Aglibot issued her own checks to Santia made her personally liable to the latter on her checks without the need for Santia to first go after PLCC for the payment of the loan. So in this case, dahil surety si Aglibot, then she is not entitled to the benefit of discussion. Ayan. All right. Diba ganda ng case? All right. Now, the next case is Atok Finance Corporation versus Court of Appeals, GR number 80078, May 18, 1993. Okay, so here, the Supreme Court ruled that a guarantee may be given as security for future debts, the amount of which is not yet known. Okay? A surety agreement is valid and binding even before the principal obligation intended to be secured is born. Ayan. So ano to? Premature guarantee? Wala pang utang, may guarantee na? Let's see. Facts. Sanyo Chemical Corporation as principal and Sanyo Trading Corporation along with the private stockholders of Sanyo Chemical executed a continuing suretyship agreement in favor of Atok Finance as creditor to jointly and severally guarantee the payment of any and all indebtedness of Sanyo Chemical heretofore now or hereafter made, incurred, or created, including that arising under successive transactions, which shall either continue the indebtedness from time to time or renew it after it has been satisfied. Now, Sanyo Chemical then loaned, nagpautang si Sanyo Chemical, umutang, okay, 100,000 pesos from Atok Finance and in exchange assigned its trade receivables to Atok Finance. Sabihin trade receivables, this could be cash, this could be credit, this could be stocks in trade. Ayan. So, inassign ngayon yan kay Atok Finance. Yun yung payment doon sa utang ng 105,000 pesos na inutang ni Sanyo Chemical kay Atok Finance. Now, Sanyo Chemical, however, failed to pay its loan and also failed to deliver the trade receivables which it earlier assigned to Atok Finance. Atok Finance sued Sanyo Chemical and its sureties for the amount of 120,240,000, including penalty charges. The defendants opposed, claiming that the suretyship agreement was void for not being supported by a valid pre-existing obligation as required by Article 2052 of the Civil Code. So, hindi pwede ang premature guarantee. So, kailangan meron na talagang valid existing obligation before the guarantee is executed. So, issue whether the surety agreement is void for having been executed without a pre-existing obligation. Ruling. It is true that a guarantee or a suretyship agreement is an accessory contract in the sense that it is entered into for the purpose of securing the performance of another obligation, which is denominated as the principal obligation. It is also true that Article 2052 of the Civil Code states that a guarantee cannot exist without a valid obligation. However, Article 2053 of the Civil Code also provides that a guarantee may also be given as security for future debts, the amount of which is not yet known. Comprehensive or continuing surety agreements are in fact quite commonplace in present-day financial and commercial practice. A bank or a financing company which anticipates entering into a series of credit transactions with a particular company commonly requires the projected principal debtor to execute a continuing surety agreement along with its sureties. By executing such an agreement, the principal places itself in a position to enter into the projected series of transactions with its creditor. With such surety agreement, there would be no need to execute a separate surety contract or bond for each financing or credit accommodation extended to the principal debtor. So, kaya valid yung continuing guarantee that was entered into between Atok Finance and Sanyo Chemical as well as the stockholders. All right, now the next case is JN Development versus Philippine Export and Foreign Loan Guarantee Corporation. Ayan, maganda tong kasong to. As in, I love this case. GR number 151060, August 31, 2005. Here, the Supreme Court ruled that a guarantor may pay the obligation once demand is made on him. Okay? We have always said that the guarantor is liable only if the debtor cannot pay. Okay? And not when the debtor fails to pay. Okay, but here the court said a guarantor may pay the obligation once demand is made upon him. Also, excussion is a right that may be waived by the guarantor. Imagine that. Ano sabi nito sa excussion? That the creditor cannot compel the guarantor to pay unless and until the creditor has exhausted all remedies against the debtor. Pero dito, excussion is a right that may be waived by the guarantor. And lastly, a debtor is bound to pay the guarantor what it has paid to the creditor. So tingnan natin ano yung situation kung bakit ganito yung ruling ng Supreme Court. So facts. JN Development Corporation obtained a loan from Traders Royal Bank in the amount of 2 million pesos guaranteed by Philippine Guarantee. JN and its stockholders executed a deed of undertaking to assure repayment to Phil Guarantee. Now, JN failed to pay the loan to TRB upon its maturity. As a result, TRB demanded payment from Phil Guarantee. Okay, after paying TRB, Phil Guarantee sued JN and its stockholders for collection. The trial court dismissed the complaint, ruling that the failure of TRB to exhaust its remedies against JN precludes Phil Guarantee from seeking reimbursement. So the issue are as follows. Whether Phil Guarantee is precluded from recovery because it failed to assert the benefit of excussion against Traders Royal Bank, and also whether JN is liable to pay Phil Guarantee. So the ruling of the Supreme Court, the creditor must first obtain a judgment against the principal debtor before assuming to run after the alleged guarantor, for obviously the exhaustion of the principal's property cannot even begin to take place before judgment has been obtained. The law imposes conditions precedent for the invocation of the defense. Thus, in order that the guarantor may make use of the benefit of excussion, he must set it up against the creditor upon the latter's demand for payment and point to the creditor available property of the debtor within the Philippines sufficient to cover for the amount of the debt. That's the general rule. Okay. While a guarantor enjoys the benefit of excussion, nothing prevents him from paying the obligation once demand is made on him. Excussion, after all, is a right granted to him by law, and as such, he may opt to make use of it or waive it. Philippine Guarantee's waiver of the right of excussion cannot prevent it from demanding reimbursement from petitioners. The law clearly requires the debtor to indemnify the guarantor what the latter has paid. Diba? So, pag winave yan ni guarantor, babayaran niya yung creditor, then he has the right to recover. Si debtor kasi hindi niya pwedeng erase yung benefit of excussion because the benefit of excussion is not a duty on the part of the guarantor, it's a right. And all rights can be waived. Kaya pagka binayaran na niya, hindi niya ginamit yung benefit of excussion, then pag binayaran and that benefited the debtor, definitely the debtor is legally and morally bound to pay back the guarantor what it paid to the creditor. Okay, postscript or PS. It must be noted that in this case, the guarantor paid the debtor's loan after the expiration of the guarantee contract. Okay. Sabi natin kanina doon sa modes of extinguishment of guarantee that if the guarantee has a specific period and if the period has already expired, then the guarantee is extinguished. Okay. But take note, okay, of this case. Okay, the guarantee was valid up to December 17, 1980. JN's obligation became due on June 30, 1980, okay, prior to the expiration of the guarantee. Demand was made on field guarantee on October 8, 1980, also prior to the expiration of the guarantee. And field guarantee paid TRB on March 10, 1981, or about 3 months after the expiration of the guarantee contract. Here, the Supreme Court held that what is controlling is that default and demand on field guarantee had taken place while the guarantee was still in force. It would definitely become immaterial if the payment made by the guarantor happened after the expiration of the guarantee contract. Ayan, o, di ba? I saved the best case for last. Ayan. So, that's it. I hope you learned a lot from this video. If you found this video helpful, please hit that like button. If you have questions or if you just want to say hi, sige na, say hi in the comments. Wag nang mahiya. Okay. Also, you can find me on Facebook. My Facebook page is Attorney Aljamrani. And of course, this is my channel. This is House of Law. So if you're new to the channel, please subscribe. Okay. Please turn that notification bell so that you will be alerted of my new uploads. And also, please share, okay, so that we can help more students, more bar reviewers. All right. So that's it from me. I'll see you in my next video. Laging tatandaan, isip ay buksan, alamin ang batas.